Hello, I'm Ken Swinton, and I want to speak to you today about two sections of the regulation bill. You've already heard our concerns regarding the rule of law and its trenching upon by the Scottish ministers in terms of this bill. Perhaps the most egregious example of this is contained in section 49, and I'll speak about that first. And then I want to also look at section 51, which is the proposed change of name for the Scottish Legal Complaints Commission. Okay, section 49, first of all, confers on the Scottish ministers powers to either create their own body to operate as a regulator of legal services, or alternatively, to directly regulate legal service providers in Scotland. There is one break on that power, and that is the consent being required of the Lord President. You've already heard our concerns that this politicises the role of Lord President, and in our view it is simply not a sufficient protection. The other criteria on which the Scottish ministers must be satisfied is that legal business providers are not being effectively regulated by implication by existing regulators such as the Law Society of Scotland. How do you test effective regulation in the view of the Scottish ministers? It seems far too open for them to even open this Pandora's box, and it's clearly designed as a stick to ensure that the Law Society conforms to its agenda. Now, if we think about the changes that were made in the 2007 Act and the 2010 Act, then the Law Society of Scotland has established a regulatory committee. That regulatory committee has at least 50% lay representation and must have a lay chair. So why would the Scottish ministers not be satisfied with a committee that is already to a large degree independent of the Council of the Law Society, of which it is a subcommittee? One change proposed in the bill will actually enhance that degree of independence that the regulatory committee enjoys. At present, Council of the Law Society effectively vet and determine members of the regulatory committee, but in terms of the bill, in terms of section 11 of the bill, the regulatory committee will have the exclusive power to appoint its own members and run its own application and appointment process. So it will be completely independent. It seems quite unnecessary to have these section 49 default powers. Okay, the second point that I wanted to concentrate on was section 51. And section 51 proposes to rename the Scottish Legal Complaints Commission as the Scottish Legal Services Commission. Now this seems again entirely inappropriate, and we can only think that it's the Scottish Legal Complaints Commission that has asked for this change. The role of the Complaints Commission doesn't change significantly under the new bill, and it is still the principal gateway for complaints, which will now comprise three categories: conduct complaints, service complaints, and regulatory complaints. Now, by regulatory complaints, it seems to be intended that this will cover where a regulated business, an authorised legal services provider, doesn't conform to the terms of its permissions. For example, if it is restricted to, say, court matters only and not conveyancing matters, then if it undertook conveyancing work, it would be operating out with the terms of its licence. And that's one example of a regulatory complaint, and another would clearly be a failure to comply with the accounts rules. So those are the three types of complaints which the Commission would have to deal with. At present, the Complaints Commission also has certain very limited oversight roles in relation to the Law Society of Scotland, and that doesn't change in any material way in relation to the bill. So it has an oversight on the handling of conduct-related complaints, looking at the timescales, etc., that the Law Society have for dealing with such complaints and whether they are complied with. And it also has an oversight role in relation to the Client Protection Fund, the Guarantee Fund, as it's actually provided for in terms of the statute, and the Master Policy really falls out with its current scope of inquiry. Why then would it change to the Scottish Legal Services Commission? It seems inappropriate. It doesn't deal directly with legal services. While the Complaints Commission may think it's a regulator, it isn't a regulator. It doesn't authorise anyone to practice, so it's not a regulator, and naming it as the Scottish Legal Services Commission, in our view, is an entirely misplaced change proposed in the bill. There are certain things that are perhaps not quite so bad in relation to the Complaints Commission, and that is its ability to reject complaints as premature or as ineligible without significant inquiry, which is required at the moment. That will cut down on their time involved and should allow staff to process genuine complaints more readily. You've already heard about Section 20 of the bill, where the Scottish ministers are given power to issue directions in relation to, for instance, the Law Society of Scotland, and the measures it can do in terms of this are setting performance standards, demanding action on particular issues, public censure, and fines. Now, what's interesting is that the Legal Complaints Commission, in terms of the 2010 Act, is not subject to directions from the Scottish ministers in the same way, nor is it subject to approval of its finances. Its proposed budget is submitted to the Law Society of Scotland for comment. The Law Society can make comments, but the Commission can go their own sweet way. Their accounts have to be laid before the Scottish Parliament, but there is no process for approval of those accounts. So, in our view, it's quite marked that Section 20 applies to regulators, but it doesn't apply to the Complaints Commission. This in itself suggests that the Commission provides an entirely different function, and it's wholly inappropriate for it to be renamed the Scottish Legal Services Commission. Finally, in passing, I would note that in terms of Section 21, regulators such as the Law Society may be approached by authorised businesses to provide a derogation from the current regulations, and the Law Society can give a derogation, perhaps from, say, conflict rules on the basis that an alternative or new means of providing legal services is proposed. Nobody knows what this alternative means of providing legal services is. Either you do something for a client or you provide advice to a client, and it doesn't change whether that's done face-to-face, over the phone, in writing, or by video call or whatever. These are not new legal services. They're just alternative means of providing the same service. If there's any attempt to derogate from anti-money laundering regulations, that would strike us as a very serious breach of the money laundering regime. I also note that the bill provides that any fee refund ordered by the Complaints Commission is to be treated as a breach of professional indemnity, so that it's covered by the master policy in the event of default by the firm. So if the firm becomes insolvent, suddenly the master policy is at risk for insolvency events rather than negligence events. And that to me seems one further inappropriate step that's made in the bill.